Good morning, sir. Very good morning, sir. This is Tangaraj from Sonaculture Technology. Good morning, sir. Am I audible?
Good morning, sir. Am I audible?
Yeah, good morning, sir.
How are you, sir?
Yeah, sir. Fine, sir. Yes, sir. Call பண்ணுங்க. A warm good morning to everyone.
Good morning, sir.
Now we can uh, start the online webinar on intellectual property rights, Indian and international law, and overview. As a token of love, we first welcome our guests and students for this webinar. So I now I request our Honorary Secretary, Senthil Kumar sir, to welcome the gathering.
Thank you, Dr. Thangaraj. So, good morning to all, respected principal, respected professors, and respected chief guest of the day, Professor Dr. Bhupal Bhattacharya. So, it's a great privilege to host you on this August Monday for this program on IPR and recent developments, that is legal aspects. So, as on date, this intellectual property rights is a big domain. So many of the students, they are involved in various discoveries and inventions. And these intellectual property rights play a major role in protecting their inventions and discoveries. So hope this session by Professor Dr. Bhupal Bhattacharya will be very useful to all of us. And since the target audience is basically from engineering background, and we are not more inclined towards intellectual property rights at all. So hope this webinar will be useful to all of us. So on the behalf of IA Salem Local Center, I thank the management of Sona College of Technology and Department of Information Technology for arranging this wonderful seminar on intellectual property rights. So we wish you all success, and we thank you all, and hope this will be a more knowledge sharing session. Thank you all. Have a wonderful day.
Thank you very much, sir. It's a privilege and an honor to introduce our today's guest speaker, Dr. Bhupal Bhattacharya. Sir, actually accomplishing his career as an administrator and educator at the graduate and postgraduate level. Also, sir has outstanding track records in high quality research and drafting. Also, sir is an effective communicator with excellent planning, organizational and negotiational sense, as well as the ability to lead, reach consensus, establish goals, and attain results. Sir received a internationally recognized award called the Protection of Nature and Environment Award by GECL on 21st November 2020. Also, sir is awarded being the first topper of the college and the second in the university in the entire LLB program on 15th May 2020 by his law college. Also, sir now working as an assistant professor in the Department of Law and Rangoni University, Government of West Bengal, India, since 27th January 2020. Also, sir has a responsibility for international law, company law, and law related to copyright. Sir's administrative responsibility consists is a coordinator for internship and the placement committee, also moot court committee member. I said professor in the Department of Law. Sir interested the subjects like 5 years BA, LLB, and BA, LLB Honors, Consumer Protection Act, and Motor Vehicle Act, then Principle of Taxation. Also, sir, supervising 8 LLM students in the discussion work. Also, sir consists the administrative responsibility as a guest and a special lecture coordinator, also NAC coordinator in the college. Also, sir has the additional responsibilities like guest lecture and special sessions coordinator, and the coordinator faculty of law, NAC committee, and also judged national and international moot court competitions in various universities. Sir's additional academic responsibility performed are guest and special lecture coordinator, advisor for law students internship and placement committee, head Amity Law School, Amity University, Mumbai, in absence of regular HOD, also exam coordinator, teacher in charge for Law College in Durgapur, then website in charge Law College Durgapur, discipline committee member, also a consultant for Sikkim Manipal University, Agadala. Also, sir published a few books and published more number of scopus and essay indexed journals. Sir attended a lot of training programs, and also he delivered a lot of lectures. Thank you very much, sir, for your time and the knowledge you are sharing to our students and the community. So now the floor is yours, sir.
Thank you so much, sir, for giving a very generous introduction about me. A very good morning to all the participants, the organizing team of the Department of Information Technology, Sona College of Technology, the Institution of Engineers, India, the Institution of Engineers, India, local chapter, Tamil Nadu, State Center, Dr. Thangaraj Kesavan, sir, who has contacted me and he's regularly pursued me to engage a lecture, guest lecture actually, the associate professor over there in the Sona College, Honorable Secretary, sir, and all the participants and all the organizing members of the organizing team. So it's really my privilege for getting an opportunity and also getting a platform where I can share my views. Actually, since sir has just now mentioned that I'm from law background, so I'll be covering the legal aspect, and I'll be taking care of the expectations of the students because they are basically from engineering background. So I'll be trying to focus on the case laws and as well as the recent developments made in the IPR. So with this, I'm going to start. So sir, sir, can you please go to the next slide, please? Yeah. Right, sir. Thank you, sir. So, since many of you have already read what is basically intellectual property rights called, what is intellectual property, what is basically a property, and I hope that many of you also do not have that much of knowledge, but still, considering that aspect, considering that expectation, I'll be touching the basic concept as well as I'll be trying to focus on that aspect. What is the recent development been made in the present days? So let me move from the part. Let me touch that part actually where the human life actually focuses on. So basically, there are 4 objects of human life. If you refer about the human life, if you refer about the ancient texts, we can easily find that human life centers around 4 objectives. 4 objectives. The first one is called artha. The second one is called kama. Third one is called dharma, and the fourth one is called moksha. Artha means money or the purchasing power. So if you have got the purchasing power, you will be fulfilling the first objective of your human life, the artha. The second one is called kam. Kam means the lust, the desire, the wish, etc., etc. So if you are living a life and if you're wishing for something, if you are desiring for something, if you are having some kind of lust towards something, that's called kama. The third one is called dharma. Dharma means how you are going to lead your life, what rule, what law, what principle you have in your life through which you are fulfilling your wishes. So let's say one person is having the expectation to have, say, 1 lakh rupees in his bank account in, say, next 5 days. So how come he can generate that 5 lakh rupees or 1 lakh rupees? He can earn, he can engage into, he can use his skill. Or say if one thief is there, if he decides, no, I'm not going to work for 4 days, on the last day, I'll steal some properties, valuables of some other person. So that way I'll be receiving money. So these are your expectations, these are your principles, that how you are going to fulfill your desire. So these are basically called dharma. So how you are fulfilling your desires, what principles you are giving at utmost priority in your life, these all are part of your dharma. And the fourth one is that is called moksha. Moksha means salvation. We believe that if we perform good thing, good deeds are being done in our present life, then we'll be getting a very good life in our, after our death. So that is called moksha. That is called salvation. So once all of your four objectives are being fulfilled, these are the primary consideration of human life. So since we will be focusing on IPR, intellectual property rights, I'll be only stressing on the first objective, that is called artha, that is called money, or that is called the purchasing power. So let me explain that if you are having a purchasing power, if you are having money, with those money, what you will be doing? Either you may pass that money for your future generation so that they can have a better life, they can have a better living, or else you can think of that, yes, I'll be having a luxurious kind of living. I'll be using this money for buying all those luxurious products. Say, for example, I'll be buying one car, or I'll be buying one, say, AC, or I'll be buying, say, those things, whatever will be giving me the best satisfaction. Right? Say, for example, I'll be buying one Twitter. Elon Musk has bought Twitter 3 or 4 days back. So these are all your expectations. So with only money, you can fulfill your expectations if that is being done in material sense. So that means if you're having money, you can buy property, right? So with those property, you can accumulate gradually. So more properties, more luxurious kind of thing. Let's say if you ask question to, say, Ambani, Mukesh Ambani, so why Mukesh Ambani, why you are, since everybody knows that you are very, very rich. Or say if you refer about Adani, he is also very, very rich person. So after having that much of money in his bank account, but still they are every time looking for different kinds of avenues, different kinds of, say, business plans, so that they can earn more money. So once you are having money, you will try to accumulate more money, accumulate more property, because satisfaction is somewhere very distant for every person who always chases their living. So that is called accumulation. Or since the central activity may involve creation of something, like say you are having a very good intellect, and you are thinking that every time, or say you are, say, an Einstein, you got the Einstein, or you have got the brain of Einstein. So people have given you the responsibility, please discover something, please innovate something, please find out new kind of things, so that human community can have a better livelihood. So that means with all those ideas, with all those mind, you can create a new thing which is very much required for your survival, or for the survival of the society, for the betterment of the society. And the third central activity of a human being, that is called the enjoyment. So once you are creating something, once you are accumulating something, you will be engaging into that kind of practice where you will be enjoying your life. So more property, more creation, more accumulation, you will be having a better life. That is called the enjoyment. Now, moving to this slide. This slide absolutely talks about, defines what is basically a property. So how we can define a property? Property can be classified into 2 categories. I hope you all are aware of. But still, I am going to give some highlight to those points. The first one is called personal property, and the second one is called property of the common. So if that's personal property, means what? That with those property, nobody is going to put restriction, put obstruction in its use. Say you are having a flat, or you are having a car, personal car. So can anybody restrict you? Then no, you can't drive this car. Or for you are only permitted to drive this car for only 1 hour? Definitely no. Because somewhere when you are buying some property, you will be having the one intention, that there should not be any single person who will be putting restriction on you not to use that property, right? So that property will be known as your own property, self-acquired property. For example, just now I've given, say, buying a car by your own money, or say buying a land, or buying a real estate property. All these are your real property. Real property means you can absolutely use those property without having any encumbrance from any side. The second kind of property, that is known as property of the common. Property of the common, that means what? Say, for example, you are studying in one institution, say the Institution of Engineers. That is the institution, Tamil Nadu State Center. or say Sona College. That is the institution. So who owns that property? I hope it is a government property, or I hope that's a public property. So if it is a public property, every beneficiary is the owner of that property, because that is the property of the common. So if that is the property of the common, everybody will be enjoying the benefit from the property, but nobody will be claiming ownership over that property. So like say environmental resources, say if your air, quality of air in your surrounding is good, so that means the people of that particular locality will have a very good living, right? So that is called environmental resources. Or say if your road condition is good, so that means you will be having a, or you can say carry out a journey of say 100 kilometers say within 2 hours. So that means environmental property. In what sense? In the sense of property of the common. Now where we can fit actually the concept of IPR in that property? Just now I mentioned that property may be of your self-acquired property, or property may be of the common property. But how IPR can be fitted into? IPR, that means intellectual property rights. Intellectual property itself says that anything which comes from your mind. So if any idea is there in your mind, with that idea, if you are developing something, developing a concept, or developing a property, or say developing a process through which a property or a product will be developed, will be innovated, that is called your intellectual property. So if law is there to protect your rights, intellectual property rights, that will be known as intellectual property rights or intellectual property laws, right? Now we can refer about the quote statement of Salmond. Salmond is a very famous jurist of contemporary times. So what he said that unnatural product of a man's brain. See, he has used one term that is called unnatural product. What is the meaning of unnatural product? Unnatural means anything which do not have any kind of spontaneous growth. Spontaneous growth means what? Say for example, you are having a vacant land, and in that land some grasses grows say spontaneously. So that is a natural product. So he is focusing on one thing that is called unnatural product. So anything which comes from your mind, not spontaneously from the environment. So unnatural product, if comes from a man's brain. So let's say you are conceptualizing a plan that he can drive a vehicle with water. So nobody has that kind of thing. So you all are engineers, you have made a plan, you have made a theory that yes, with 1 liter of water, mind it, it's not a petrol or diesel. With 1 liter of water, we can drive the vehicle for say 1 kilometer. Everybody will be the happiest one if they find out this kind of technology or this kind of vehicle which can run with the fuel in the form of water. So he has said that unnatural product is a like of a man's brain, which is very valuable like that of his hand or like that of his goods. So if you are having a good, say for example, I am having a phone. So this phone is very valuable for me. Like this is my hand, is very valuable because with this hand I can do many activities, right? So these, like he has compared the product, his idea, innovation with his hand, that innovation, if that can be materialized, is as valuable like that of your hand, is as valuable like that of your personal goods. And law has an obligation, mind it, where he has stressed that law has an obligation. What kind of obligation? That law must recognize that the person who is having that kind of intellect, who is developing a new concept which can be materialized, that concept, that idea should be protected, should be recognized. So that is a statement of Salmond. So what I view personally, that if intellectual labor, intellect means your idea, your thoughts, your innovativeness, if you're with your intellect, if you are exercising intellectual labor, if you're using that intellect and accordingly you are putting an effort with your spatial skill, where you are having the spatial skill, if you're developing a property, that should be given the utmost recognition as the property of that particular person. Let's say somebody has say invented this as a spec, or says invented one particular say pen. So that this is a pen, and this pen can be used for writing purpose. So whoever has invented that pen, he has initially thought, yes, I'll be making a pen, and with that pen, I can write down whatever is there in my mind. Just please hold for a minute. Basketball, ওই ঘরে দেখুন বাঁদিকে রাখা আছে। বাঁদিকে। Sorry. So if somebody who has invented that pen, and if he decides, if he makes up his mind that yes, I need this pen because whatever idea is coming into my mind, that retains in my mind for say next 7 days. After 7 days, I start forgetting about that idea. Now the question is, if you are inventing one particular pen, if you're inventing a say how to write or the way techniques, or if you're inventing a diary, so where we can write down all those things, you can retain those ideas for a long period of time. If you can retain it properly, that can be passed also to the next generation, right? So these are all your ideas. So what I personally feel, that if you are having an intellect, if you're using your intellectual labor, if you're using your intellectual skill and accordingly developing a property, or an idea has been developed which can be materialized, that must be properly recognized. That is my point of view. Sir, can you please move to the next slide? Next slide. Yeah, thank you, sir. So since we are focusing on the intellectual property, basically intellectual property consists of patents, it consists of copyright, it consists of trademarks, it consists of industrial designs, it consists of geographical indications, and the last one is called trade secrets. So we have different laws for different kinds of aspects. I'll be stressing on those every point. If you're referring about patent, that means you're inventing something, a new product has been developed, or a new process through which a product is getting developed. So for which a law has been passed, and that law has been passed in the year of 1970, which talks about recognizing patent rights, Patent Act of 1970. So if you are developing a property which has got an innovativeness, uniqueness, yes, that requires, that expects some kind of recognition, and that recognition can be sought, can be claimed from that law, that is called Patent Act of 1970. The second one is that just now I had mentioned, that is called Copyright Act. What is Copyright Act? Copyright Act means if you are writing down something, let's say you are writing say novel. So once you are writing a novel, people will be very curious to read it. Let's say you have kept the price, you have published that novel in a book format, and you have kept the price of that particular book for say, or for the novel for of rupees say 5,000. So everybody will not be interested to buy that book. So if they find that one of their friends has bought this particular book, they'll be interested in making a photocopy of that book, right? So if they're making a photocopy, that is the violation of the intellectual property, and that is known as copyright violation. And for which we have a law that is called Copyright Act of 1957. So we have a Trademarks Act. Trademark Act means what? If you are developing a property, if you are using it under a brand name, let's say Tata Steel, or say Tata Vehicle, Tata Car. So Tata is using a particular logo, T, and that is getting circled. Within a circle, T is there. So with this logo, we can be ensured that yes, we are buying a product made by Tata. Tata is a trustworthy company. So if Tata is making making a product, and they are selling this product with this brand name, with this particular logo, so by looking at logo, you can easily come to know that yes, this is the product of the Tata, and we can trust it. So how come they will be using this logo? For which we have a law that is known as Trademarks Act of 1999. We have Industrial Designs Act passed in the year 2000. We have Geographical Indications Act passed in the year 1999. We have Trade Secrets. So basically, intellectual property or Government of India has tried to pass different laws so that every innovativeness, every uniqueness, every new kind of activity should be recognized. So if you're referring about intellectual property, now the question is why I should ask for recognition of my activities, recognition of my innovativeness. because we all believe that until and unless we have a monopoly right over my creation, I cannot be very much, say, encouraged to do a new kind of thing, to innovate a new kind of thing in the next future, in the coming days. So that's why Government of India has thought that I should give recognition to every person, so that they should be encouraged to develop, to invent, to manufacture a new kind of thing in the future, so that development can be continued. So that is the sole purpose. The second sole purpose is known as, you are giving monopoly right to the inventor, monopoly right to the creator, monopoly right to the author. So once you are giving monopoly right, he will be getting some kind of royalty, he will be getting some kind of money or monetary benefit, financial benefit. So we all know that, just now I had mentioned that human life centers around 4 activities, and amongst which the first one is called artha, money. So if you are getting money, you will get more satisfaction, right? So satisfaction can be earned, money can be earned if your activity, if your innovativeness is getting recognized by the law. So that's why Government of India has passed different laws in the name of Patent Act, in the name of Copyright Act, in the name of trademarks, in the name of industrial design, in the name of geographical indication, etc., etc. Right. So I must mention that in the year of 1474, for the first time, patent right was granted. Patent right was granted for the first time in the year 1474. For what reason? For manufacturing, for inventing glass. So once that glass was manufactured, government of that particular nation, I hope it is of Russia, they realized that yes, we should encourage that particular person for innovating that particular glass, because that is going to give huge impact, huge benefit for the human existence, human survival. So next slide, please. Yeah. So that particular slide I had already mentioned that we have Patents Act of 1970, which is going to recognize, or which recognizes the patent right for making different innovations. We have a Copyright Act of 1957, which protects the literary work of the performers, of the say artists. We have Trademark Act of 1999, which protects the trademark as well as service mark as well. We have industrial designs, whatever design you are going to make, which appeals your eyes, that is also getting protected from with the Design Act of 2000. We have geographical indications. So if any product can be tagged with a particular geographical locality, yes, from that locality, this particular product can be tagged, and according to that product will get huge, say, commercial value. So no other person should use that particular label, that particular names, for which we have the Geographical Indications Act of 1999. And we have a different law, civil laws, in the name of trade secret. There is no specific law is there, or I mean special statute is there to protect trade secrets. I'll be explaining trade secrets in my next slide. So next slide, please. Yeah. So in this particular slide, say from this particular slide onwards, I'll be focusing on the basic concept of intellectual property, the kinds of intellectual property. Side by side, I'll be focusing on certain case judgments. Why case judgment? Because case judgment will be giving you a proper idea so that you can visualize that what is going on, what kind of development is going on, has been made with the interference of the judiciaries. So that's why I'll be focusing on the case judgments. So let me come to the basic concept of patent. Just now I had mentioned that if you are inventing something, if you are having, or if you are developing a new product which has got a novelty, novelty means a new kind of thing, uniqueness is there. Say for example, the person who has for the first time invented a particular vaccine in the vaccine which can work against COVID disease, corona disease, must require protection in the form of patent, because it's the first vaccine been made within India. By whom? By Serum Institute or say Bharat Biotech. They have invented. Somewhere novelty is there, somewhere uniqueness is there, and it is going to give benefit to the society, where chaos, where hue and cry had started within the society, that I don't know whether I'll be surviving after one day. If I get affected with COVID, if I get affected with corona, yes, I might not survive in the for another say 7 days. So there was a huge demand, huge requirement, huge expectation for the government that government should spend money on the research and innovation. And accordingly, two companies had come up with the new idea of manufacturing the vaccine, which can work or which has actually worked. So that's why they had asked after that for the purpose of patent. So just now I mentioned that once they had invented a product, a vaccine, which can work against, say, corona disease, so that product has got the patent right, patent protection. Now the question is, what about the process? So if you come to know that we are going to mix up AstraZeneca with, say, some antibiotics, and with this, if you use a Calpol, paracetamol with this, it can work against the, say, COVID disease. If you come to know about that. Yes, that is a process. So company may also patent the process. So we have two laws, two policies for getting the patent. The first one is called on product, you can have the patent. And the second one is called on the process, how you're going to make the product. On that also you can have the patent. So patent requires certain criteria to be fulfilled. The first one, just now I mentioned the novelty, whether uniqueness is there, whether newness is there, new kind of thing. If you're developing a new product, yes, you can go for asking recognition in the form of patent with this new product. The second one is that is called non-obviousness. What is non-obviousness? Say, for example, we can regularly observe, we can regularly see that in a ceiling fan, there are 3 blades. But sometimes we see that 4 blades are there, 5 blades are also there. 4 blades, 5 blades. So what is the new kind of thing in that product? If you are having a ceiling fan with these 3 blades, if you can cool down the surrounding, cool down the atmosphere by using that 3 blades fan, yes, definitely with 4 blades, it may give you more cooler atmosphere, fine. So what is the non-obvious? What is the obvious? It is a kind of obvious thing. Increasing the number of blades might give you a cooler, say, atmosphere. So that is called obvious. So if obvious kind of thing, you will not be getting any kind of patent. So you need to fulfill that criteria too, that your product is a non-obvious kind of thing. You developed altogether a new kind of thing, which requires a protection. The third is whether your product is going to give benefit to the mass, to the large section of people. Whether you are going to put that property in the public domain. If yes, you'll be getting the patent. So you need to give a statement, a declaration that yes, please give me protection for a certain period of time. And after that, I'll be allowing that property, that product, that innovative kind of thing for the betterment of the whole society after a certain period of time. So for a certain period of time, I'll be exercising some monopoly rights over that property. After that, that property will be the public property. So that must be there in the public domain, and that must be used for public purpose. So if yes, if all those characteristics are getting fulfilled, you are entitled for the purpose of recognition in the form of patent. Now the question is, for how long you can have a monopoly rights? We can have monopoly rights for 20 years. 20 years. Now you may also ask me the question, sir, you have just now mentioned about Patent Act of 1970. Which country has passed that law? I had already told that Indian Parliament has passed this law, the Patent Act of 1970. Now, if the next question comes, sir, if Indian Parliament passes that law, Patent Act of 1970, whether that law is applicable in Bangladesh, whether that law is applicable in, say, Sri Lanka, or say Bhutan, or say US, or say UK, I'll answer the no. This law has a territorial boundary. This law will be only using within the territorial domain of the government of India, territory of India. So beyond that, this law does not have any application, right? Now you may ask me, sir, if there's no application, let's say you are putting all those, or sharing all those information that how this fan can be invented, can be manufactured, or say how one AC can be manufactured. You have shared all those information. Now, if with those information, if a person from US makes a fan like that particular product which you have developed, which you have discovered, or you have invented, so whether your law is going to put restriction on that person, US person, I'll say yes. How? for which we have a international policy. We have TRIPS agreement, we have WIPOs, we have GATT agreement, etc. So different agreements, different conventions, different protocols have been made through which international community are also getting obliged to recognize the patent grant of one person, one resident who has got the recognition within his particular territory. So if an Indian person invents something, he will equally get protection in outside India too. In which country? Those countries whoever are the signatories of the TRIPS, signatories of the international policies. So basically it's of 20 years duration. After 20 years, you won't have the monopoly rights over it. Now let me go to the development part. Patent, what is the development? I'll be just now, I had also previously mentioned that I'll be through case law, I'll be explaining that one. The first case law I mentioned here over it. That's a Novartis versus Union of India. Novartis versus Union of India. So Novartis is basically a company, basically a pharmaceutical company who had invented a particular medicine named as Gleevec. So the company had obtained patent right for manufacturing that particular medicine. So once they realized that yes, 20 years time is going to get elapsed. So after 20 years, I won't be having any more monopoly right over that property, and that particular medicine can be manufactured by anybody within this territory, within or outside this territory. So that drug will be made available to the whole world. So what plan they made? They thought that yes, I'll be using some other substances in that medicine. So they used some additional substances in that particular medicine, and they discovered a new product, and they again made an application to the patent office that yes, we have discovered a new product, and this product has a different substance. Different substance means previous substances are also there, but I'm using a new substance in a new quantity. Let's say earlier quantity was used by that particular Novartis company. Say 2 molecule was used. Now they had used 3 molecules in that product, and they are asking for getting the patent right over it, so that they can have a long duration of time. So that matter has been questioned before the patent office, and patent office said no, this cannot be done. We cannot give you any more patent right over it. So Novartis has challenged. No, why? Earlier we used 2 molecules, now you are using 3 molecules. We are using a new substance over it. So why you are not giving it right to us? Finally, that matter has gone to the Supreme Court. The Supreme Court has said, no, you are not permitted. You are not permitted to get patent right after the expiry of the previous patent duration, because it is already a known drug. This particular drug is already working on a particular disease. So if you are using one more substance, a new substance in that particular drug, it is not giving you the more benefit, the same benefit we are going to get. So by a new name, if you are thinking of to get a patent for a new term, new duration, that is not permitted. And that is a recent development being made in the year 2013. Supreme Court has said that no, this kind of patent right cannot be given once a known thing has been modified by a new substance. Say for example, this is the pen. So if you are using a particular, or if you are making a new pen where you can write from this side as well as from that side, whether patent right can be given? Definitely no. Why? Because it is not giving you the more benefit. It is an already known thing. So if there is not giving you a new kind of invention, yes, you will not be getting any more patent. So restriction was imposed on Novartis case, Novartis company. Like I have also mentioned about one new case. Compulsory licensing is a case of compulsory licensing between case of Bayer Corporation versus Union of India. It's the case of 2014. Bombay High Court has given the judgment. I hope you all are aware about compulsory license. Can anybody of you, if you are audible or if you can listen to me, can anybody of you answer that? What is compulsory licensing? Have you heard about this? What is compulsory licensing? Any one of you? Okay, no issue. Okay, what is compulsory licensing? Compulsory licensing is a provision is there in the Patent Act of 1970, which puts restriction on the company who invents product. That if you are inventing a product, you'll be getting a patent right with the condition that you will be manufacturing the product and you will be making the product available to the common person, to the society. So if you are to enhance the price, if you are not manufacturing in a sufficient quantity that particular product, your license will be withdrawn. So your monopoly rights will be withdrawn. Your product will be handed over to a new company, to a new person, new company, whoever is interested to manufacture, whoever is interested to produce, right? So this, with that particular matter, Bayer Corporation case has come up. Sir, my slide is not visible actually. Okay, I'm continuing. Sir, please, with the request that can you please play the slide again. So, what happened in this matter? Bayer Company had invented one particular product, cancer medicine, and named it Nexavar. What happened? You know that Nexavar was not getting produced, was not getting manufactured in a sufficient quantity. So accordingly, patent office had decided. Accordingly, the patent office has decided that this particular license given to the Bayer company should be withdrawn. So accordingly, that particular in the third slide, I hope. So that particular cancer drug that license was withdrawn from the Bayer company, and that was given to the Netco Pharma. Yeah, this slide only. Thank you, sir. So that particular license was being given to the Netco Pharma. So what happened actually? Bayer company, B-A-Y-E-R, Bayer company had invented one cancer drug, and since they did not manufacture for a sufficient quantity, that's why their monopoly right was withdrawn after a certain time, and that monopoly right was given to whom? To the Netco Pharma, with the condition that Netco Pharma has to produce generic version of the medicines, so that can be access, that can be procured by the cancer patients in a large quantity. So that's why Netco Pharma got engaged into that. Netco Pharma was given the second condition that you need to pay royalty to whom? To the Bayer company, because you are using or you are manufacturing, you are producing that particular drug which has been invented by Bayer company, and they have got the patent over that. So that's why Netco company has been directed to pay royalty to the Netco company, to the Bayer company. The third condition was given to the Netco Pharma was that they need to donate 6,000 free medicines to the public, free of cost. 6,000 numbers of free medicine to the public. Third condition. Now, fourth condition was given to the Netco company Netco Pharma was they cannot lease, they cannot license that particular manufacturing of that particular product to one new company. So that condition was being given. So simultaneously, one development was also being done. Bayer company got very offended with this because they felt offended. Why? Because they invented a cancer drug medicine. They got patent in their own name, but some other company is manufacturing it with their technology, using their concept. They are manufacturing it, and they felt very much cheated. So what they did, they started simultaneously producing that particular medicine because they have also got the concept. They invented that one. So they started manufacturing medicines simultaneously, and they started selling that medicine with a different brand name to the market at a higher price. Now the question arises that the company which has invented the product that particular company is also manufacturing and is selling the product at a higher price in a different brand name. And simultaneously, one new company, Natco Pharma, who has been given the permission by the patent office to manufacture that drug, is also manufacturing. So they are manufacturing a generic version of that product. So generic version is a very less costly product, or less costly drug. So question arises that which company is permitted to sell the product to the market? Both are selling the same thing, same component with the same component in a different brands. Finally, matter has been heard by Bombay High Court, and Bombay High Court has decided that no, this activity should not be permitted. Since compulsory licensing was been given to the Natco Pharma, only Natco Pharma is permitted to continue with this operation. And Bayer company has been directed to restrict down their operation. They have been asked to stop down their process. So that judgment has been pronounced in the year 2014. So that is a new development being made in the present days. So next slide, please. Yeah. Well, two more developments I have also focused in this particular slide. In this slide, I have mentioned about removing form and fees for publication international application. I had already mentioned that the Patent Act of 1970 only gives you protection within the territory of India. So beyond the territory of India, you will not be getting any protection. So how come international community will come to know that this particular product is being patented within the territory of India? So that's why you need to make an application to the international community, international organization, right? International organization, you need to make an application so that they also can retain the document. So for which we have a WTO, World Trade Organization, which works on it, which preserves the record that which company is giving patent right to what product. So let's say you are from Tamil Nadu. In Tamil, you have developed the product. The language you have used is Tamil, and you have applied in your local language, you got the patent. Now the question is whether international community is aware about your language. Definitely no. They are not aware about Tamil. So we consider that English is the common language which can be understood by most of the nations. So that's why you need to make an application by converting Tamil to English, and that application must be made to the international forum. Now the question is, if you are from Tamil background, you are not aware about English, in that case, how you will be making the application? Definitely, we can hire some services, fine, and for which certain fees are also prescribed. Now the question is, why you should pay more fees for making international applications? What is going to give you more benefit? You have invented something. Government of India has given you the patent right, and now you are intending to give intimation to the international community, and they are asking for the fees, and you do not have proper money to pay. So that's why this is a new development that this fees is no more required, to be paid. So that is the new development in the patent law. One more development has also been done. I've also mentioned in this slide that if let's say you are making an application to the patent office for the purpose of getting a patent recognition, and patent office finds that some minor errors are there in that particular application, and that need to be rectified. So if that is allowable, if that patent right is recognizable, if they find that yes, most of the content, most of the parameters have been fulfilled, and that is allowed, then they can give you the permission that yes, you will be getting the patent right, because everybody is in a hurry. Patent office, Indian government is also in a hurry, that until and unless we give immediate recognition, there is every chance that the person of different person, or say person of different nation, may get the patent in their own name. So that's why the person who is actually invented that thing, they like say Jagdish Chandra Bose, he invented radio, but some other person claimed, because he didn't go for patent right, some other person claimed that he invented first. So that's why we do not give priority, we do not give recognition to the Jagdish Chandra Bose, who had actually invented radio. So that's why the time limit has also been reduced, and the patent office has also been asked that if you find that this is allowable by substantive examination, by making minor amendments, please allow. Please allow. So that's the new development. So next slide, please. Yeah, thank you, sir. So in this slide, I'll be talking about the copyright. I had also previously mentioned that I'll be focusing on the basic concepts, and thereafter I'll be moving to the new developments. So what is the basic concept? What copyright talks about? Copyright says that if you are having a literary idea, that literary idea requires protection. So what is literary idea? Let's say you are writing something, or writing a novel, or say you are writing a drama, or say you are performing something, musical kind of thing you have developed, or artistic work you have developed, you have made. All those things requires protection. Or say if you are say directing a film, that in this way this film will be played, or will be directed, will be made. This thing also requires protection. So your protection is not only getting confined to only say things which have been only written. So anything in whatever format, in literary format, in dramatic format, dramatical manner, in musical format, in artistical manner, in a film format, whatever, you will be getting the protection. Now the question is, what's the duration of the protection? The term of the copyright is of 60 years, 60, right? 60 years. So 60 years from which date? Let's say Rabindranath Tagore has written a particular novel. So in the year of say in 1930, he wrote that one particular novel named say A. He expired in the year say 1941. I'm not I can't remember in which year. 1944, 1945 he passed away. So let's say he passed away in the year 1944. So whether after his death the protection of copyright will end? No. His protection will continue for 60 years. 60 years. From that particular year, that year in which he died, excluding that year, from the next year onwards, 60 years will be taken into consideration. And after the passing of 60 years, his work will be placed before the public domain. Whoever interested wishes to change it, modify it, use it, he is permitted to do so. Now the question is, if two authors are there, let's say you are writing up a say article. In this particular article, two authors are there. The first author is Mr. A and the second author is Mr. B. Mr. A passed away in the year 2020 with Corona. Mr. B passed away in the year 2022. Now, from which year 60 years time period will be counted? Whether from 2023 onwards, because in 2022 the second author died, or from 2021 onwards, because the first author died in the year 2020. So from which year actually 60 years would start? It's from the year of the death of the last co-author. Also, if co-author is there, last co-author, the year in which he will die, from the next year onwards, 60 years time period will be taken into consideration. So that is the law about the protection of the copyright. Now the question is, what is the development about the copyright? We can refer about the Star India Private Limited versus Moviestrunk.com and others. In the case of 2020, very recent case, passed in the year 2020 by Delhi High Court. So Delhi High Court in this matter has received a petition. In this petition, what Star India did, Star India is basically a TV channel. So they basically played a particular movie been made by some other organization, Moviestrunk. One particular Moviestrunk has made a movie, and that movie was been played by Star India without taking any permission. That matter has gone before Delhi High Court. Now the question is whether Star India is permitted to play that movie, or Moviestrunk has got any kind of right to restrict Star India not to play that movie. So the contentions have been placed before the Delhi High Court. Star India said, see, we have the channel, TV channel. Our responsibility is to play the movies, and accordingly, whatever movies are available in the market, we are playing one after another. and we are paying royalty to them also. So whatever money we are getting, simple rule is that we are paying some part. Let's say we are earning 100%, and we'll be sharing say 10%, 20% with the actual owner of that particular. So that way thing goes. So Star India said we are not denying the royalty to the Movie Strand. We are the channel and we are playing the movie. Movie Strand said, see, you have not obtained permission from me. We are not interested to play the movie in your channel, because we find that if my movie will be played in your channel, that way mass people will watch that movie, and I'll be losing my market, because I'm only interested to play my movie in the theaters first, and thereafter I'll be releasing it in the say OTTs, and thereafter to the general platform, say TV channels. So different contentions were raised before the High Court. Now that matter has been heard in length by the Delhi High Court. Delhi High Court has said in the 2020 that, see, if someone has a copyright over it, in this case, Movie Strand has got the copyright over that particular film. So what is the purpose of having the copyright? That they are having the monopoly right, how to use it, what money they should earn, how to earn that money, when to earn, etc., etc. So these are their monopoly rights. So if you being a TV channel, fine, we are also giving you the recognition, but that doesn't mean that without permission you can play that movie. You can play the movie subject to previous permission. So if you have not obtained the permission, you need to pay damages. So you are violating the copyrights. So that was the outcome of that particular judgment, recent outcome. So accordingly, Star India Private Limited has been asked to pay damages to the Movie Strand because they didn't obtain any permission. So that is the overall judgment. So next slide, please. Yeah. In this slide, I'll be explaining about trademark. So I had already said that the Trademark Act has been passed in the year of 1999. So what is trademark? How we can define trademark? What is the purpose the trademark serves? In this case, in this matter, trademark can be defined that if any particular company is manufacturing something, they will be using a logo in that product. Say for example, if Tata company is making a vehicle, or say Apple company is making a phone, they are using a logo of Apple, right, in the back side of that particular phone. So by looking down at the apple, someone has taken one bite from that apple. This kind of logo is there with one leaf, one logo is there. They use that kind of logo. So what is the purpose of putting that logo in our product? Simple purpose is that this particular product can be easily identified by the consumers. So that carries a value, that carries a reputation, that carries a goodwill. So if you're using an iPhone where this particular logo is there, the logo defines that who has actually invented, who has actually manufactured, who has actually produced that particular product. So from which company you have obtained that product, who is the actual manufacturer. So whether you are belonging to a particular rich class, aristocratic class, or poorer section, depends upon what kind of phone you are carrying. So if you are carrying an iPhone, yes, you will be belonging to a rich class, aristocratic class. So that's why the purpose of trademark serves. So the purpose is to distinguish that which product is being developed, or is the product of Apple company, or is the product of say Redmi company, or is the product of say Samsung company. So by looking down at the logo, we can come to know. Just not given the example that if Tata company is making the vehicle, they are getting dependent upon importing or buying the tires from a different company, because they do not manufacture tires. So this I don't know, I'm not aware of, but still, let's say they are procuring tires from MRF company. If MRF company is supplying tires to the Tata company, and Tata company thinks that no, this vehicle will be sold in our name, Tata logo will be there. That's why there should not be any more logo in that entire vehicle. So if MRF company is putting their logo, MRF, Madras Rubber Factory, that kind of logo in that particular tire, and this particular tire is being getting installed, getting assembled with the final shape, final product, final vehicle, that will affect the reputation of the Tata company. Let's say Tata company decided they will be putting a label over it, so that MRF company, MRF word should not be visible to the consumers. If they start using a label over the MRF word, MRF trademark, that will be the violation of the trademark, right? So that is not permitted. So what is the recent development? Recent development is, in these days we can have service mark 2 registered. So earlier trademark was also permitted to be registered. These days we can use service mark 2. The service mark means you are not dealing with goods, you are simply dealing with a service. Let's say Volvo service. Volvo is a kind of bus they are manufacturing, and it has a special kind of luxurious kind of thing. So you will have a less jerking, you won't feel tiredness while traveling a long distance. That can be easily traveled, long distance can be easily traveled, long roads can be easily covered, etc., etc. So these are the facilities, these are the benefits, these are the advantages of traveling with a Volvo bus. So Volvo bus is using a logo, VOLVO, and they are using like say V kind of thing. This is a service mark. So trademark basically deals with both goods and services. But if you are referring about service mark, yes, if you are absolutely dealing with a service, you can have your service mark registered. So that is the new development being made in these days. So you can register your logo, you can register your symbol, you can register your brand, heading, label, name, signature, word, letter, whatever you can think of. If it can identify your product, if it can distinguish your product, or if it can distinguish your service from the rest of the products of the entire world, that will be known as registered trademark. Now the question is, for what's the duration of the protection? If we are going for registering the trademark, duration is only for 10 years. So don't get disheartened that you are establishing a company, and this company's product will have a trademark, and that trademark is valid for 10 years. After 10 years, we'll need to have a different trademark. No. This 10 years can be renewed. So after every 10 years, you'll be getting renewed 10 years time, right? So that will go on and on. Okay. So since I had promised you that I'll be focusing on the recent development, I'll be focusing. The first case law is Yahoo Incorporation versus Akash Arora and another. It's a case of 1999, Delhi High Court. So in this particular case, what had happened actually, Akash Arora, he started a new website within the territory of India, and he named his website as Yahoo India. We are very much aware about Yahoo. Yahoo is a brand name of US company who are basically a search engine, which also engages in different kinds of products, also gives you the various kinds of news, etc., etc. And what Akash Arora did, he developed a website and named it Yahoo India, which is quite identical to the Yahoo company, Yahoo Incorporation. So Yahoo Incorporation has filed a case against Akash Arora. Why you are using this term? We have a registered trademark in our name, Yahoo, and you are using Yahoo India. Akash Arora responded before the Delhi High Court to see, we are not using only Yahoo. Yahoo is a dictionary word, right? Yahoo is a dictionary word. So we should also be permitted to use the dictionary word whenever we desire. And we are also not going to cheat you, because we have added one more word with it, Yahoo India. It's not only Yahoo. You are using the brand with the only Yahoo, but we are using Yahoo India. And simultaneously, we are also giving a disclaimer in our website that this Yahoo India is the registered trademark or say registered company of Akash Arora. It doesn't have any bearing with Yahoo. It's absolutely a new company. Yahoo has given their contention, has raised their contention. Likewise, Akash Arora also did. Akash Arora said that yes, we have used only dictionary word, and you have also used one more word, added one more word, India, so that people can come to know that this is not Yahoo actually. Now, when that matter was heard in length by the Delhi High Court has come down to the conclusion. What conclusion Delhi High Court has given? That if you are permitted to use Yahoo India in your website, this name has been used, in that case, it has a potential to confuse internet users, and that will deceive the consumers. So if you're using Yahoo India, this has the potential to deceive consumers, because everybody will not be in a conscious state of mind that they will be reading down your entire disclaimer. So this is somewhat different from Yahoo company. And they will get confused because you are consuming the time of the consumer. People believe that Yahoo is a company, they have a good brand name, and Yahoo company is delivering a product or is engaging into a product, that will be a very good product because they have a good goodwill. And all of a sudden, if you are engaging into a business and you are using Yahoo India, that will confuse the consumers, and that should not be permitted. Accordingly, Akash Arora has been restrained not to use this word because that is a violation of the trademark policy. Right? I hope you have got to know about the entire concept. I've also referred one case, Facebook Incorporation versus Mr. Nofel Malol. It's a very interesting case of Bangalore, nearby to your state. In this case, Facebook, you all know, I hope everybody is having the Facebook account, 1 or 2 accounts, their own name, Facebook. So Facebook is basically open social media platform through which we interact with our friends. We can come to know what other persons are doing in their life. The virtual platform, Meta. That way they have engaged into the business. And Mr. Nofel Malol of Bangalore, what he did, he had developed a product in the name of FaceBake, FACEBAKE, FaceBake. He has also started using one more, given a new name to one more product, FaceCake. See, Facebook, BOOK. But he is using 2 products. One is called FaceBake, BAKE. The other one is called FaceCake, FACECAK. So, which is quite similar to the name of the Facebook company, right? Now, what he started making his products available in the Snapdeal. I hope you all are aware about Snapdeal, like say Amazon, like say Flipkart, Snapdeal, etc., etc. So these are the commercial platform from where you can easily buy the different products. So different companies are making their products available in those commercial online platform from where you can, being a consumer, you can easily buy the product. So once Mr. Nofel Malol started making his products available in the Snapdeal, people started buying those products in the name of Facebook, in the name of FaceCake. Now the question arises, Facebook felt that no, see, my reputation is getting harmed. In my reputation, some other person is doing his business. So they simply given a notice to Snapdeal. They asked Snapdeal to check that why they are permitting Mr. Nofel Malol to sell their product in the name of FaceBake or FaceCake. Snapdeal has responded to see, FaceBake is something different from Facebook, FaceCake is something different from Facebook, and we are not permitting Facebook, we are not permitting anyone to use the name of Facebook. So that's why it should be legally permitted. Matter has gone to the Delhi High Court, and Delhi High Court has given a very interesting judgment in this matter. Delhi High Court has given a direction to the Snapdeal. They look, if you are permitting different products to be made available in your online platform, people will get confused. People will get confused. So you should have a responsibility to find out a mechanism so that those deceptive practices should be stopped. So if you can develop a mechanism, that is, through this mechanism you can identify that this is not actually Facebook, this is a FaceBake or FaceCake. This product should not be made available on your online website. So you please find out a mechanism. Second direction was given to the Snapdeal to immediately stop down marketing those products. Third interesting point Delhi High Court has given is that Meta, Facebook, was being permitted to hold all the products of Nofel Malol whatever products are made available in the website, whatever products he has invented, he has manufactured in the name of FaceBake or in the name of FaceCake. So a direction was given to Nofel Malol that please deliver whatever products are being manufactured in your custody, in your possession, in the name of FaceBake or FaceCake to Facebook so that they can be disposed of effectively. Nofel said that please, I will be disposing it of. Court said no, I don't trust you. You please deliver those products to Facebook, to Meta, so that they will be effectively disposing those. So accordingly, that matter has ended. Third judgment I had referred here in the slide, Bajaj Electricals Limited versus Gaurav Bajaj and Janardhan. This is a very interesting case. In this particular case, I hope you all are aware that Bajaj is a very brand name. They have been engaged in different electrical products, different vehicles also. So like that way, Bajaj is a surname of one particular community. So one particular person, I forgot his name, what he did, he started he incorporated a new company in the name of Bajaj. His surname is actually Bajaj. So he started a new company in the name of Bajaj, which is quite identical to the Bajaj Electricals Limited. Bajaj Electricals Limited. Gaurav Bajaj, yeah, I have written in the slide itself. So Gaurav Bajaj, since his surname is Bajaj, he started a new company in the name of Bajaj. Interesting part of that case is Gaurav Bajaj has given a tagline to his product. In every product, he has given a tagline. What tagline he has written? Powered by Bajaj. Powered by Bajaj. So that means somewhere it has affected the business of Bajaj Electricals. Bajaj Electricals has filed case against Gaurav Bajaj that please stop down your operation. You are not permitted to use Bajaj. Gaurav Bajaj, while responding to Bombay High Court, has said that my surname is Bajaj. You can't restrict me not to use my surname. So whatever I am doing is with the good intention, the bona fide intention I am doing. So they said that they are legitimate person to use their surname as their product brand. But still, High Court has restricted them. High Court has said that Bajaj word has become a well-known trademark over several years. They have done business for a long period of time. That's why they have got a well-known trademark, well-known mark. And accordingly, Gaurav Bajaj was given an injunction, prohibited injunction, that please don't use word Bajaj in your product, because that will make confuse the consumers. Even if we appreciate that your surname is Bajaj, but still you are not permitted to use Bajaj as the label of your product. So that way, in the year 2020, a very recent judgment, in the year 2020, that matter has ended finally. So next slide, please. Yeah. So what are the recent developments been made in the trademark? I'd already explained that earlier there was a law that if you are developing a product or if you're developing a service or you are providing a service, you can have a trademark. The trademark used to cover both your goods. If you're manufacturing a good, let's say you are manufacturing a pen or say a phone, yes, that phone can be used with this particular trademark. And like that way, if you're providing any kind of service, yes, trademark can be used. But in these days, what is the recent development? In these days, trademark, the word service mark has come into picture. If you're engaging into service, yes, you can use service mark. The service mark is absolutely meant for services. If you're engaging into service, you can have a service mark. So there is no much difference in it, but still to identify if you're engaging into services, you can have a service mark. The trademark will be dealing with both this. It's a generic word with the goods as well as services, whereas service mark will be only used for the purpose of services. The second development is in these days you can have a trademark on shapes. Let's say you are referring about the Apple phone. Apple, if you are taking a picture of one apple, it looks always same. Whoever is taking the picture of apple, it will look like the same, but they have a different kind of shapes in it. It's a one bite apple. Somebody has taken one bite. but this one leaf is there. So it is a unique shape. You can easily identify this is a particular logo. If this unique shape has been done, a graphical representation has been made, or say color representation has been made, color combination has been made, yes, that also can represent, that also can be added in your trademark, right? In your trademark. Let's say if you are buying, just now I've said, if you are buying say Apple phone, every time you'll find a silver colored logo is there. So can other person use the silver colored Apple logo in their phone? No, because that will be violating the shapes, violating the color combination, graphical representation of the Apple company, not permitted. That is the violation. That is a recent development, right? It's the same thing what I had previously explained, that if you are making an application for the purpose of getting your trademark registered, if there is any alteration required, you find that some mistakes are there, minor mistakes are there, this court or say trademark authority will be permitting you to make the to have the trademark registration, and they will simultaneously ask you to go for correcting the clerical alteration, clerical mistakes. So they will not be delaying you, they will not be consuming your time. So that is the recent development. Recent has been said, has been asked all the trademark authorities to immediately dispose of the applications. Recent development also includes the earlier trademark policy. Earlier trademark policy was only applied, only allowed for 7 years, but nowadays you can have protection for 10 years. You can have protection for 10 years. So for 10 years, for 10 years, you can have the protection. Now the question is, I have already previously said that for 10 years, you are having the protection. After the expiry of 10 years, you are permitted to go for re-registration. You can ask for renewal of it. So once your registration time will be over, after that, you will make an application for the purpose of renewal of it. So again, for another 10 years, you will be getting the trademark protection. So that way, thing will go on. So initially, registration will be valid for 10 years. Earlier, that was for 7 years. That is the recent development. Okay, so next slide, please. So continued processing or for trademark application. This is also the new development in the year 2022 only. This development has been made. What it talks about, that if, let's say, you are running a business with a particular trademark and your time period of 10 years has passed, right? And you are thinking of to make one fresh application for the purpose of renewal. So what was the time period previously allowed? Earlier, you were permitted to make application within the period of 6 months. So within the period of 6 months, you were permitted to make an application. Now the question is, in the name of development, that 6 months time period has been reduced to 2 months. Why 2 months? Because court or say trademark authorities are also not aware that whether you are really intending to continue with your business. So if you are engaging into business on a certain date, after the 10 years, you may decide to stop down your operation, right? So if you are permitted to permitted to make application for within another 6 months, that will restrict, that will reduce the authority, reduce the third person's power, third person's expectations. Because third parties are also interested that if you stop down your operation, they will start their new venture by using a different kind of logo, which might be similar to the previous logo. So the earlier 6 months time, gestation time was compulsorily, that was a kind of compelling thing, was been asked to third party to wait. But in these days, that 6 month time period has been reduced to 2 months. And that way, if you do not turn up within the period of 2 months after the expiry of 10 years duration of trademark, your application will be lapsed, right? So that is the recent development being made. So next slide, please. Yeah. In this slide, I'll be talking about design. What is basically a design? Design means anything which you develop, which appeals to your eye, a unique kind of thing. Let's say we find that say one particular product which has a color combination of say pink and blue looks like good, right? So if it looks like a slim kind of thing, that means if some other person does or manufacture the similar kind of product with the similar kind of shape, with the similar kind of design, they'll be violating your design guide. So that is basically a visual test. So if you are making a design, that design, you will be getting the protection for 10 years from the date of your registration. And the design can be renewed for another 5 years. So mind it in this point very carefully, that after the expiry of 10 years, you will be getting renewal for another 5 years. So that means in total, you will be getting protection for only 15 years. So 10 years initially, after that 5 years, 10 years plus 5 years, 15 years. After 15 years, no more protection. That property will be placed before the whole world, common world. So there will be no more protection after 10 years. So you may say, sir, after 5 years, whether we are permitted to go for re-registration, re-renewal? No. After 10 years, one time renewal is permitted for another 5 years. After 5 years, no, it's not permitted. Right? So next slide, please. The same application, same rule is whatever I explained in trademark is applied in design. It talks about that if you are thinking of to go for a renewal of your design after the expiry of 10 years, yes, I said that you can make an application for another 5 years, right? But within what date, within what period you can make the application? Time period is 6 months. So you are permitted to make an application for 6 months. Let's say you are not thinking, you are not intending to continue or to have the renewal of another 5 years. In that case, but that will be a compelling kind of thing to the other person, to the third party, to wait for another 6 months. So that's why the new development in the made in the year 2022, that 6 months time should be reduced to only 2 months, so that balance of interest with the third parties can be easily made. So next slide, please. This is a very interesting part, geographical indication. As I had previously promised that I'll be explaining the basic part as well as the recent development also. In this geographical indication, what is basically geographical indication? Geographical indication means any property, any product, if it is getting manufactured in a particular territory, or say any natural product is getting produced in this particular territory, will have a particular brand name. Let's say Darjeeling tea, or say Assam tea. So Assam tea, if you are using Assam tea, that means the tea which is getting produced within the territory of Assam, within the territory of Assam. So let's say West Bengal also engages into tea production. Karnataka also engages in tea production. Let's say Karnataka government, or say one particular company which is also equally engaged into tea production in Bangalore based. They produced some tea and labeled that particular product with the word Assam tea or say Darjeeling tea. Whether they are permitted? Definitely no. Definitely no. Why they are not permitted? Because Assam tea has got a different brand name. Darjeeling tea has got a different brand name. So like that way, if that brand name is getting affected, you will be restrained. You will be restrained. That no, you are not permitted. So anything which has got a geographical origin, or which can be tagged with a particular geographical area, that particular tag name can only be used by the producers or by the manufacturer who are manufacturing the products within that particular territory. So if you are not placed within that particular territory and you are placed in somewhere else, you will not be permitted to use that particular brand name. Like say, I can give more examples. Say, neem case, turmeric case. Turmeric case has been settled in the year 1997. Turmeric is basically haldi, been used by Indian for the purpose of antiseptics for a long period of time. Since Indian government had not given true focus on development intellectual property rights, that's why different countries have started giving patent on turmeric products. Like Japan, like US, like say UK, they have started giving patenting rights. So when government of India has realized that their products, their products are getting patented in different locations, in different territories, they raise the matter before the international forum. So finally, international forum has realized that no, this is the Indian made thing only. So India government has got a rich heritage in using the turmeric product as an indigenous activity. So like that way, you cannot use those things. You cannot give the turmeric product of India, etc. These kind of words cannot be used. Like that way, judgment has been pronounced in the favor of government of India. So that has been settled in the year of 1997. So like that way, if neem, US government has started giving patent to US companies using that neem product. So that was also challenged by government of India. Finally, that patent was also withdrawn because that is already in practice within the territory of India. So that is the practice of indigenous community within the territory of India. So that's why that patent was subsequently withdrawn. With the request of the government of India, that was withdrawn in the year 2005. Recently, Basmati rice case has also come into picture. US government has allowed some company to sell the variety of one particular rice in the name of Basmati rice. Government of India has raised their objection that no, Basmati rice is a particular variety of rice produced within the territory of India. If you use a different, if you tag or if you are permitted, if you allow some companies to use the word Basmati rice for a different variety of rice, that will make people confused. That should not be done. And accordingly, that has been restrained in the year 2020, 2001. That thing was withdrawn. So like that way, I can give now n number of cases, n number of judgments on that matter. Like say, if you refer about Agra ka Petha. So if you are visiting to Agra, Petha is very famous over there. Agra ki dahi, lassi. These are very famous kind of things. West Bengal also, rasgulla. Rasgulla is a sweetener dish made of milk product. So sweetener dish, a few days back, that matter has been raised. A dispute has been arisen between government of Orissa with the government of West Bengal. So government of Orissa claimed that Rasgulla is their product because from 13th century onwards, this particular product, this particular Rasgulla, is being offered to that's called Jagannath temple in their bhog. So they started use. They asked that geographical Indian, this word should be connected with us only, so that we should only be permitted to use this word Rasgulla. Whereas government of West Bengal has given strong objection to it. Government of West Bengal said that in the year of 1844, I hope 1844, 1894, I forgot the date. In that particular year, Nobin Chandra Das has for the first time invented Rasgulla. So Rasgulla belongs to West Bengal, whereas Orissa government claimed that Rasgulla belongs to Rasgulla. They are saying that Rasgulla belongs to Orissa. That matter has finally been heard by Supreme Court of India, and Supreme Court of India finally given the judgment in favor of West Bengal to some extent. But Patent Office has said that no, we are not going to register it in the name of Rasgulla only because it has come into the public domain. Everybody, if they are having say a sweetener kind of dish, white sweet made of milk, dipped into huge quantity of sugars in a liquid form, they call it a sweet. They call it Rasgulla. That has become a public word, common word. So that's why you later use a different term along with it. So government of West Bengal agreed with it. Government of India said Bangla Rasgulla. So that way they have made a different kind of Bangla Rasgulla. Orissa said that yes, we are also agreeing with it. Orissa Rasgulla. So that way, no matter has been finally settled. The Rasgulla belongs to common property, common term, and West Bengal government, even that government claims that Nobin Chandra Das is the first person who has invented that sweet dish that should be used as a Bangla Rasgulla. Orissa should use this word as that's called Orissa Rasgulla. Now the question is for how long? For how long geographical indication registration is valid? For how long? So basically, this validity, the registration validity is of 10 years. Is of 10 years. So you can have protection for 10 years. Right? Now the question is, what if your registration gets expired? Whether this product will be made available to the whole public? Answer is no. So it can be renewed. So there is no limit prescribed that till what extent this validity can be restricted. So that's why after every 10 years, you can again make a fresh application for the purpose of renewal of the geographical indication. So if you belong to a particular locality, if you are engaging into this kind of practices, or say if you are growing tea by staying in Assam, you can use this term Assam tea. If you're staying in Darjeeling, if you're producing tea, you can use this term Darjeeling tea. If you are say staying within the territory of India, if you are making or producing a particular variety of say rice, you can use it in the name of basmati rice. But if you are staying in outside India and you are using the same variety, same technique, same kind of thing, by producing say tea, by producing say rice, you cannot have the name of Assam rice, Assam tea, Darjeeling tea, or say basmati rice. So these are the differences. The next slide, please. Traditional knowledge. Yeah. So that thing is very important. I have repeatedly referred about this slide. I said about case of neem, which has been settled in the year 2005, basmati rice, which has been settled in the year 2001, turmeric case, which has been settled in the year 1997. It talks about traditional knowledge, indigenous knowledge. So what indigenous knowledge talks about? It talks that if any knowledge is there in the public domain, that will not be given any kind of protection by any international community, right? So if that is there in the traditional knowledge, the international community should ensure they are not giving protection, that they are not giving any patent to any product or any knowledge, whatever is available for a long period of time in the indigenous thought. So if it is there, that will belong to traditional knowledge, and traditional knowledge will get its own protection. So Government of India is committed to give protection to all those traditional knowledge, right? So next slide, please. So next slide, please. Sir, am I audible? So please go to the next slide. So next slide, please. Anyways, there is some network issue, I think, from the admin side. Anyways, in the next slide, I have referred about that is called trade secret. Trade secret. So what is basically trade secret? Trade secret means any secrecy which you are maintaining for running your business. I can refer about the case of Coca-Cola. Coca-Cola basically mixes some ingredients in developing their beverage, in developing their soft drink. So if whether they have obtained their patent, answer is no. They have never gone for asking for patent, because they are very much aware that if they go for asking for patent, that patent will give them the monopoly right for 20 years. So after 20 years, the knowledge will be in the public domain, and they will no more be getting any more benefit, any kind of monopoly rights after the expiry of 20 years. That is the restriction, right? That is the restriction. So they thought that we'll be doing the business for centuries after centuries. We will not be going for only 20 years of business. So that way they made the plan that will not be sharing the idea. So you can you can look down into the label of that product, the Coca-Cola beverage, Coca-Cola bottle, that they have never shared what kind of ingredient they are using, what kind of sweetener they are using. So every time you will be buying the Coca-Cola bottle, you will find the same taste. Every time you'll be buying the Pepsi or the Thumbs Up, they will be getting the same taste. But the question is how they are making it, nobody is aware of. Now the question is that if somebody who has been hired by say Coca-Cola company, if he is engaged into manufacturing Coca-Cola by using those ingredients, he will come to know that what kind of ingredient in what quantity is being used. Sir, am I audible, sir? Sir, am I audible?
Yes, sir. Yes, sir.
Okay, sir. Okay, sir. Sir, I have requested you to move to the next slide. Actually, I thought that some mistake, some problem is there for admin side. That's why I said, yeah. Thank you, sir. Thank you. So, let's what example I was giving, that if Coca-Cola hires some employees, and those employees are aware of that what kind of ingredients in what quantity should be mixed, so that Coca-Cola can be manufactured in the similar to whatever has been manufactured in the last year. So year after year, they are keeping the similar taste. There is no change actually. So if the person who has been hired, who knows about those techniques, shares those information to their competitors, or say after retirement shares those information, in that case, what preventive measure Coca-Cola company can take, what preventive measure, what action they can take against those employees. So for which we have a law that's for trade secret or confidential information, which says that if someone comes to know about the information, still he is not permitted to share those confidential information to the competitors. If they are doing so, in that case, they will be liable before the civil court for the purpose of paying the damages, paying the compensation. So we have a case, the Diljit Kita's case, recent case only. Diljit Kita's case is a lawyer who is running a law firm. So he engaged some what I can say, some interns as well as some associates with him in his Delhi firm. So associates started writing down the applications, how to move to the court, etc. So those associates, when got disassociated from that employment, claimed that whatever petition we had drafted, these are our petition, these are our intellectual value, intellectual rights, and we should get the copyright over it. And that law firm for which we worked should not be given the copyright. That should belong to us only. So finally, that matter has gone before the Delhi court. Delhi court has heard this matter, and Delhi court has made a point of distinction, point of difference, that whether it is a contract of service or contract for service. Contract of service means what? Contract of service means if you are hiring someone on day-to-day basis. If any person who has been hired on day-to-day basis, whatever work he will be doing, on that work, he will be having the copyright. Right? So on day-to-day basis, if somebody has been hired, copyright belongs to the employee. But if you are hiring for us against a remuneration for say 30 days, for say 5 years, etc., that will be known as contract for service. Contract for service. So if it is for a specific period of time, in that case, copyright will be made available to whom? Not to the employee, but to the employer. So in that particular case, Diljit Kita's case, in that particular case, Delhi High Court has finally settled this matter by saying that whatever drafts, whatever petitions have been drafted by the lawyers, by the associates, by the interns, should belong to only the law firm, because the law firm has given the employment. So that's why employer should have the right. So there is a confusion between who, sometimes employer gets the right, copyright, sometimes employees get the right? So that way thing can be decided, and Delhi High Court has given a very clear-cut judgment that how this can be settled, that if it is for contract of service, it should be belong to the employees. It is for contract for service, in that case, it should belong to the employer. Right, so that thing has finally settled the matter. So next slide, please. Yeah. So since I'm from law background, I think that legal remedies should also be focused on. So what are the legal remedies? All of a sudden say your right, your trademark, your copyright, your patent, your design has got violated, your registered trademark has been violated. In that case, what remedy do you have? We have the right in the name of injunction. We have the right in the name of ex parte orders. We have right to surrender or destroy. We have right to claim for some cost or damages. So what is injunction? Injunction means if someone is violating your right, in that case, you can ask that person not to continue with this operation which is violating your right. That's the injunction. What is ex parte order? Ex parte order means if say you are making you have been asked, you are the defendant, you have been asked to appear before the court, and you are intentionally not appearing before the court for say 3 times. In that case, you will not be given any more remedy, you will not be heard by the court, and without hearing you, plaintiff can be heard by the court, and finally judgment can be pronounced. So that is called ex parte. Ex parte means one-sided judgment. By listening to the prayers of plaintiff, if defendant does not appear, by after getting numerous opportunities, ex parte order can be given. Number 3, to surrender or seize or destroy the property. I had said about the Facebook case. In that case, judgment was pronounced that the persons who were manufacturing products or who were selling the product in the name of Face Bake or Face Cake should deliver the product to the Facebook company, Meta company, so that they can effectively destroy it. So destroying the property so that it should not cause any more harm to you is also the third right, third civil remedy. The fourth remedy which is available to you is cost and damages. Whatever harm has been caused by other person by their intentional negligent act, you can claim for damages. You can claim for compensation from that person. So damages is the compensation. So next slide, please. Yeah. So criminal remedies are basically there for 2 types of violation. One is called trademark and the other one is called copyrights. We know trademark means the logo which is being used by the company for the purpose of identifying, distinguishing their product, trademark. And copyright means if you are you are making a literary work or thing, or you are say making a dramatical kind of work or a cinematographic kind of thing, you can have a copyright. So I said that trademark is valid for years. It can be renewed. Copyright is valid for 60 years. It cannot be renewed. But if there is a violation, in that case, what criminal remedy is available to you? 6 months of imprisonment can be awarded to the violator, to the aggressor, 6 or accused, 6 months. Minimum 6 months of imprisonment can be given, and which can be extended to 3 years. So between 6 months to 3 years, both rule is applicable for the purpose of trademark, violation trademark, as well as copyright. What monetary fine can be imposed for violation trademark and copyright under criminal remedies? 50,000 fine can be imposed. You can debit with 50,000 fines, 50,000 rupees, which can be extended to 2 lakh rupees. So that is the recent development, right? Indian patent in 1970 also says that yes, to some extent we can also impose criminal remedies if you provide false information. Let's say if you are providing or you are making falsification of entries, you are claiming false information or making false entries in the register, in that case you are liable for criminal offenses. So these are also the criminal remedies apart from civil remedies. So if you are looking for civil remedies, you will not get criminal remedy, but if you are going for criminal remedy, you won't get civil remedy. So these are the substitute of each other. Either you may go for civil or you may go for criminal. So next slide, please. Yeah. So what changes have been made in the IPR, in the trademark? In the year 2022, draft national IPR policy has been made, where focus has been given that I have already explained that for trade secret, there is no law is there. Trade secret is getting protected by the civil courts only. I have not mentioned about particular statute. So for trade secret, IPR policy focuses that it should also get equal recognition, equal protection. So let's say if Coca-Cola company is not interested to share their information to the common public, they should also get the protection. And that's why this new draft policy contains a similar provision, specific provision. Like that way, Government of India has given due concern to the pharmaceutical matters, that if you are manufacturing drugs, new drugs, or inventing new drugs. I hope you all are aware that India is one of the largest manufacturing drug makers in the entire world. So that's why Government of India has thought that we should have a proper policy regarding the protection of the pharmaceutical companies' interests. So that's why they have tried to make a balance between IPRs with the inventor or the industry who are engaged into the pharmaceutical matters. So these are the new developments which have been added in the draft National IPR Policy 2020, which has not yet been passed. So next slide, please. Yeah. So with this slide, I'll be concluding that there is a huge development been made in the IPR because the new concept, the Government of India has recently given prioritize or has started giving prioritizing this idea of making IPR recognized. So Government of India is entering into very many international conventions, policies, and becoming the signatories of the policies, is ratifying various policies of TRIPS, GATT, international organizations, so that in a proper manner, the Government of India can give protection to all the inventors, manufacturers, authors, etc., who are engaging into intellectual activities. So next slide. So these are only slides which I have made. But still, if you have any kind of question, if you have kind of want to discuss any kind of, you are absolutely free to ask.
So thank you very much, sir, for
Thank you so much, sir, for providing me the platform to explain my views on recent developments on IPR from legal point of view. I tried to explain from the various judgments. I wish all the future events of the college a grand success. So thank you all, and thank you all the participants for patiently listening to the discussion. Thank you. Thank you so much, sir.
Participants, any queries? So now the floor is open for Q&A. So if anyone have any queries, now you can ask with the today's speaker. Sir, on behalf of IAS Serum Local Center and Sona College of Technology, we thank you, sir, for your wonderful session. Also, you clearly explained each and every terminology with clear case study presentation. Thanks a lot for your timing, sir.
Thank you so much, sir, for giving me the platform and also patiently listening to me and supporting me in every way, but also by playing the slide, everything, sir. Thank you so much.
Yes, sir.
Wish you all the best.
Also, we thank our corporate members, especially Dr. Kumurel sir and other members, also our beloved students and friends. Thank you all. Thank you for joining.
Thank you.